Thank you for joining us today for a training on representing LGBTI asylum seekers, leveraging international law to strengthen asylum claims. I want to start off by introducing our panelists. I'm joined by my colleague Alice Farmer, who is a protection officer here at UNHCR in the U.S. Protection Unit. Prior to joining UNHCR, Alice worked on refugee and human rights issues in various capacities for Human Rights Watch, the ACLU, and the Norwegian Refugee Council, as well as in other offices of UNHCR. Our next guest is Fatma Maruf. Fatma is a professor of law and director of the Immigrant Rights Clinic at Texas A&M University School of Law. Fatma is a top scholar in immigration law, refugee law, and international human rights, where her scholarship has examined such issues as the rights of mentally incompetent non-citizens, the use of restraints in removal proceedings, and the exclusion of Dreamers from the Affordable Care Act. Fatma also has extensive experience representing LGBTI immigrants in U.S. proceedings. And lastly, my name is Colleen Cogill. I'm a two-year legal fellow here at UNHCR, where my project focuses on enhancing the capacity of legal representation by ensuring that lawyers and adjudicators are aware of UNHCR's position and how to use it in U.S. proceedings. Today's training is part of a series that we're conducting. Our prior trainings have focused on children's asylum claims, women's claims, and the role of international law in U.S. proceedings. And all of those trainings are available on our website. And at the beginning, I just want to mention that this training is being recorded and will be available shortly after the presentation. So in today's webinar, we're going to cover the following topics: discussion of UNHCR's work on protection of LGBTI asylum seekers, as well as available UNHCR guidance on LGBTI asylum claims, and how this guidance can be used in U.S. proceedings. Next, we'll give a quick overview of asylum, outlining the legal elements to a claim, and then jump into a discussion of current issues and strategies for representing LGBTI asylum seekers in the U.S. And lastly, we'll apply this material to a hypothetical case example. We'll also have time for questions at the end of the presentation. On the right-hand side, there is a drop-down box to type your questions in, so we'll be trying to address those at the end. And there's also on the right-hand side a drop-down for handouts where you can access the PowerPoint slides for this presentation. So with that, I'm going to hand it over to my colleague Alice to discuss UNHCR's work on protection of LGBTI asylum seekers.
Hi, first I wanted to say thank you to Colleen, and also thank you to all of you for joining the webinar and for having such an interest in this topic, which I think is particularly timely and important right now. In my role in UNHCR in the US, my job is to try and help promote the use of international law in defending asylum seekers here in the US. And I think particularly in the LGBTI field, there are some ways that international guidance and standards can be particularly useful. Here in the US, we have a legal unit that sits in Washington, and we try and provide support for lawyers and decision makers and people who are assisting asylum seekers, as well as for asylum seekers themselves who are representing themselves pro bono. And I want to emphasize that we are always available for questions or concerns, and we really do hope to serve as a resource to help people in their interest in taking on asylum cases and perhaps working on the issues that you're all working on or showing an interest in today. So please don't hesitate to be in touch at any time. So let me get a little bit more into UNHCR's work specifically on LGBTI asylum seekers. It has been an increasing concern for UNHCR globally, because as we've been able to track this issue more closely, we've noticed that the persecution of people of LGBTI origin is particularly difficult. We often see that they suffer the same forms of persecution as other people. So for instance, they might suffer as civilians in civil war. They might be targeted by gangs. but then the issues that they face are compounded by the problems that they face as LGBTI people. So the discrimination that they encounter in their home country might very well make the persecution worse. They may be less able to go to the police in the home country. The police may themselves be the persecutor, or they may be unwilling or unable to help the individuals. And then we've also seen that as LGBTI people flee from the situation in which they were facing persecution, their flight can often take them through places where they experience additional human rights abuses in the course of flight. UNHCR globally has taken a deep interest in this problem, and we've produced a recent comprehensive survey of the particular issues faced by LGBTI asylum seekers and refugees in 90 different countries that we work in. And the US has participated in that survey. So that covers countries of immediate first refuge, where you might think there is a typical refugee camp like Lebanon or Kenya, as well as countries of transit like Mexico, Indonesia, and countries of ultimate destination like the United States or European countries. So here in the US, we've been doing some work with a number of experts around the country who know more than us, including Fatma, who has wonderfully agreed to be a panelist on this. And through that, we've been trying to identify some of the particular problems faced by LGBTI asylum seekers through research and through public reporting. We have produced 2 public reports that I think will circulate. We can circulate at the end of this call, although I think they may have been linked in the original email, including one that focuses on women who have fled the Northern Triangle of Central America. And in there we cover particular problems faced by transgender women and by lesbian women. That's a particularly good example when we look at the situation in the Northern Triangle of Central America, of the fact that persecution can be deeply exacerbated by LGBTI status. So we were, for instance, looking at transgender women who fled El Salvador, Honduras, or Guatemala, and whose persecution in that country was not just the taxes and extortion and violence that many people there are facing from the gangs and government-affiliated actors, but also exacerbated problems from decades of discrimination against these groups and an unwillingness of the police to do anything to protect people from that violence. The group that we studied for this report, Women on the Run, then moved north through Mexico, moving mostly through the smuggler routes, the coyote routes. And there again, we see that women, transgender women in particular, faced difficult issues. They experienced more problems trying to ask the Mexican authorities for help, and they often experienced discrimination and violence at the hands of the smugglers themselves. And then when these groups reach the United States, again we see problems, particularly in detention, where it can be very difficult for transgender people or people who identify as LGBTI to obtain the protection that they need in facilities that are hostile to that sort of protection. And I know that Fatma will touch on that a little bit later. So this Women on the Run study covered 160 different women who had fled, and we will absolutely circulate the link to it later. But Colleen, if we wouldn't mind skipping back to the previous slide. Thank you. I went a little too much into detail there. So that's the first point, that we've been doing research and public reporting. We've also been doing some slightly less public reporting by trying to gather information that helps us in advocacy with the US government. And in particular there, we've done some work around LGBTI in detention in collaboration with some of the experts that we work with. The idea behind that is to try and work with different actors in the US government to improve protection of people of concern in the United States. Particularly for LGBTI, we've been promoting the use of alternatives to detention because we do know that detention is a particularly harmful practice for this population. At UNHCR, we take the position that no asylum seekers should be detained, but particularly for vulnerable groups, including unaccompanied children and LGBTI individuals, we definitely want to be promoting and supporting the use of alternatives to detention. And in the US, we have seen some good practices around alternatives to detention, but those programs are a little bit too small to be having the kind of impact we'd like to see. And then finally, the other piece of work we try to do on this issue is to make sure that we're supporting US courts when they are deciding cases that have to do with LGBTI asylum seeker rights. They're particularly around interpretations of particular social group or interpretations of evidentiary standards or requirements of seeking protection in the home country. We've used amicus briefs to promote the positions that UNHCR takes when these issues have come before some of the circuit courts of appeal in the US. And that's something we'll all continue to be doing. We can skip ahead now, Colleen. Another body of the work that we do here is we take in a lot of cases through a hotline that people can call us on. And there it's very useful to be able to refer people to lawyers who are willing or interested in taking on pro bono cases. So I think that's something that if you are interested in after you listen to this panel, we definitely would like to hear from you very much. Perhaps we can move to the next slide. Great. So I think that's the end of what I wanted to say here, but I'm going to stick around for questions, and certainly I'm very interested in the rest of the things that will be said. Thanks.
Great. Thank you, Alice. I'm now going to talk about international law and its relevance in U.S. courts, specifically in regards to LGBTI claims. I want to start by laying the framework for why international law is relevant in the U.S. That's a question that we get a lot here at UNHCR. U.S. obligations under international refugee law stem from the 1951 Convention relating to the status of refugees and its 1967 protocol. These instruments define the term refugee and outline the rights of displaced persons, as well as the legal obligations of states to protect them. The U.S. acceded to the 1967 protocol in 1968. The 1967 protocol binds parties to comply with the substantive provisions of the 1951 Convention. Therefore, by acceding to the protocol, the U.S. has committed itself to comply with both the provisions in the Convention and the protocol, and to provide effective protection to refugees. So this forms kind of the underlying basis of where U.S. obligations stem from. And in addition to acceding to the protocol, the U.S. has also made clear its intention to comply with international refugee law through domestic law. The 1980 Refugee Act was implemented with the express intent of bringing the U.S. into compliance with the 1967 protocol, as recognized by the Supreme Court in the case Cardozo-Fonseca. Therefore, the Refugee Act should be interpreted and implemented in a manner consistent with the protocol and the Convention. This is why the international guidance we're discussing today is relevant to U.S. asylum proceedings. So to assist with proper interpretation of the Convention and the protocol, UNHCR has created extensive guidance for states and adjudicators. This includes the Handbook on Procedures and Criteria for Determining Refugee Status, UNHCR's Guidelines on International Protection, and UNHCR's Eligibility Guidelines and UNHCR Reports. All of these resources were created to assist lawyers and adjudicators with proper interpretation of the refugee definition. The Handbook, Guidelines, and Eligibility Criteria are all resources that can be cited in U.S. courts. This slide also shows how U.S. courts have used UNHCR guidance. Courts have looked to UNHCR guidance to interpret specific legal questions, such as what constitutes persecution or how to define and interpret the term membership in a particular social group. Courts have also looked to UNHCR reports in examining conditions in the asylum seeker's country of origin. UNHCR's reports can and should be submitted with an asylum claim to provide the adjudicator with background information and context about the human rights and refugee protection situation in the applicant's country of origin. So for example, the report that Alice was just talking about, Women on the Run, can be submitted with a claim from Central America to demonstrate the conditions women, and including transgender and lesbian women, are fleeing in the Northern Triangle and Mexico. So focusing on resources relevant to LGBTI claims, in 2012, UNHCR issued the Guidelines on Sexual Orientation and Gender Identity. The sexual orientation guidelines go through an analysis of the refugee definition from an LGBTI perspective. These guidelines lay the framework for the discussion by beginning with an overview of international human rights law that protects the rights to equality and non-discrimination. And violation of these basic rights could form the basis of a particular social group, or it could be incorporated to show that the harms experienced by LGBTI persons do rise to the level of persecution. The guidelines also discuss common forms of persecution in LGBTI claims, including discrimination, physical violence or intimidation, restriction of certain human rights, and criminalization of same-sex relations. The sexual orientation guidelines also examine each of the convention grounds and how each might be raised in an LGBT asylum case, with a particular focus on interpreting the term membership in a particular social group. I also want to highlight a discussion paper that was released by UNHCR in 2010 titled The Protection of LGBTI Asylum Seekers and Refugees. This paper discusses protection gaps for LGBTI asylum seekers and refugees at various stages of the displacement cycle, focusing on particular vulnerabilities LGBTI persons may encounter. This includes causes that force LGBTI persons to flee, such as discrimination and abuse, as well as abuses they may encounter during flight and after arrival. This information could be used to inform the well-founded fear analysis as evidence of surrounding circumstances or to support the applicant's credibility. The paper also discusses the lack of understanding and knowledge regarding the complexities encompassed within the concept of gender identity and sexual orientation, which may impact how the applicant's claim is viewed by an adjudicator and necessitate more detailed explanation of these terms and how it applies to the individual's case. Another topic that could be relevant that's discussed in the paper is how laws criminalizing same-sex relations can constitute per se persecution, even when these laws aren't enforced with any regularity. As Fatma will also discuss later, and as Alice touched on, the paper discusses the detention of LGBTI asylum seekers and how detention exposes them to a heightened risk of further abuse, including sexual assault. And the paper concludes by discussing specific protection issues faced by lesbian, gay, bisexual, transgender, and intersex persons as distinct groups, which could be used as evidence of surrounding circumstances or to support the well-founded fear analysis. The last resource I want to talk about is UNHCR's eligibility guidelines. These eligibility guidelines provide legal interpretations to assist decision makers and private practitioners in assessing the international protection needs of asylum seekers. As is relevant here, UNHCR recently issued eligibility guidelines for El Salvador and Honduras that discuss certain risk profiles of individuals who may qualify for protection. I'm not going to read everything on this slide, but I pulled out a few quotes from the guidelines that are relevant to today's topic and could be used to support a claim from El Salvador or Honduras. The quotes here touch on the conditions LGBTI persons may face in these countries and could be used to provide the adjudicator with background information and context about the conditions in the applicant's country of origin. So they talk about widespread discrimination and abuse faced by LGBTI persons in El Salvador and Honduras, and the heightened abuse faced by transgender women in these countries. The eligibility guidelines for El Salvador and Honduras also identify what they refer to as certain risk profiles of individuals who may be eligible for refugee protection in UNHCR's view. The guidelines take the position that individuals of diverse sexual orientation and gender identities in El Salvador and Honduras may be in need of international protection on the basis of their membership in a particular social group or on the basis of other convention grounds. They also emphasize that individuals of diverse sexual orientation or gender identity cannot be expected to change or conceal their identity in order to avoid persecution. So here I just wanted to recap. I've included a list of the available resources, most of which we've already discussed. It includes Women on the Run, which Alice talked about, the Guidelines on Sexual Orientation and Gender Identity, UNHCR's LGBTI discussion paper, and the eligibility guidelines for El Salvador and Honduras. All of these resources were issued to assist with proper interpretation of the refugee definition, which, as we discussed, the U.S. has an obligation to uphold since it ratified the 1967 protocol. I've also included a few UNHCR amicus briefs. The most recent is the Bringas-Rodriguez brief, and that was the case concerning an LGBTI asylum seeker from Mexico. And it kind of shows how we approached the argument. And this case, UNHCR's brief focused on articulating UNHCR's position that improved country conditions, such as passing laws that protect same-sex marriage, does not suffice to reject an asylum claim. The adjudicator should also look at the situation on the ground, including whether those laws are enforced and whether they offer effective protection. And again, all of these resources are available on our website, which is the link below, but I'll also be sending out this information after the presentation. So I'm now going to hand it over to Fatma to get into the discussion of the refugee definition and how to go about preparing a brief in one of these cases.
Thank you. Okay, so I'm going to sort of walk us through the elements of asylum in the U.S., which map on very closely to the international conventions. And I'm going to use hypos throughout so that we can practice sort of applying those concepts. Okay, so we can advance from the slide. Great. So just as a little bit of historical background, homosexuality was actually a reason for excluding people from the U.S. up until 1990. So it hasn't been that long since people who identified as gay were even allowed to enter the U.S. And the first successful LGBT asylum claim was in 1994. So this is still a relatively new and developing area of jurisprudence within asylum. And one of the most recent things that happened just in 2010 was that HIV was finally removed as an automatic sort of ground of inadmissibility under the health-related contagious disease grounds. So it used to be that people who were HIV positive couldn't even come to the US without getting a special waiver. Okay, so I'm going to move forward from that. So there's two types of processes for applying for asylum: affirmative applications and defensive applications. So affirmative is when somebody is not yet in removal proceedings and basically is in the country and wants to seek asylum. These are handled through U.S. Citizenship and Immigration Services, USCIS, and the decisions are made by an asylum officer, which is somebody who's trained to adjudicate asylum cases, but is not necessarily a lawyer, and so might not be as sort of aware or understanding of legal precedents as a judge would be. The other approach is defensive, which is if somebody has already received a notice to appear in an immigration court, which is what initiates the removal proceedings. So this is somebody who is now in front of an immigration judge, which is part of the Department of Justice, and who will take a new look, so a de novo look at the asylum application. So if the asylum office doesn't grant an application, they don't deny it, they just refer it over to immigration court if the person no longer has legal status. All right, we'll move ahead. So our definition in the US in the Immigration and Nationality Act, as I said, it matches closely to the refugee definition, and it's somebody who's outside of his or her country and who is unable or unwilling to return, either because of past persecution or a well-founded fear of future persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. So that's the definition of a refugee, and I'm going to break it down into each of its component parts. So well-founded fear is the first concept. Actually, I think I'll talk about persecution first, because I think that's sort of fundamental basis for even understanding well-founded fear. and then we'll talk about the nexus, which is the on account of words, and then we'll talk about the 5 protected grounds. So to start with persecution, this is a concept that's not defined in our statute in the INA, so it's been explained through case law. And the different circuits don't all agree on exactly what is persecution, but most of them agree that it's serious harm. There's pretty broad consensus that physical harm, sexual harm, now amounts to persecution. When you get to psychological harm, you see somewhat of a circuit split. Some circuits, like the Fourth Circuit, has held that psychological harm alone is not enough to establish persecution. Other courts, like the Ninth, have said it is. So you really need to sort of familiarize yourself with the case law in the circuit that your case is in. Extremely severe discrimination can be persecution, but again, it has to be quite extreme. Usually, you'll see cases saying that mere discrimination or harassment does not rise to the level of persecution. Arrests and detentions can be persecution as well. This depends on sort of the severity, the length, the cumulative harm that the person experienced. And death threats can also be persecution if they're serious and if they're made by groups that are individuals who have the capacity to carry them out. So for example, gang members that have killed people before and can clearly execute and do execute their death threats could qualify as persecution. Whenever you're deciding if somebody experienced persecution, you look at the aggregate harm, the cumulative harm that they've experienced throughout their lives. So not just each incident, but overall, looking at everything, all the incidents together, does that rise to the level of persecution? So in LGBT cases, we see all of the usual types of persecution that were just listed. And there's some that might be sort of unique in LGBT cases or come up particularly often. So we do see a lot of isolation or stigma, which would fit under psychological harm. And so again, depending on how seriously the circuit takes psychological harm, that may be more or less persuasive to the court. But it's also important to emphasize sort of the pervasiveness of discrimination against LGBT individuals. It's not just, by one particular group. Usually it's by society at large. That would include their family, their school, their workplace, everywhere they go. So if there's that type of widespread discrimination, it can really amplify the amount of harm psychologically the person is experiencing. Sometimes our judges are not that well versed in sort of how DV also occurs in same-sex relationships. So this is also an area where, as an attorney, you might need to do a little education of the judges. And then prosecution, because there are so many countries that still criminalize same-sex acts or even identity in some cases, you've got to understand the difference between prosecution and persecution and when prosecution can amount to persecution. So if the sentence is disproportionate, that's one way that prosecution can become persecution. And I'll go into that a little bit more in a hypo later. So sexual harm tends to be quite common among LGBT individuals and is often very difficult to discuss. So at the beginning of representation, you want to make sure that you build a trusting relationship with the client and that you're not judgmental. And one thing to keep in mind is, we've been using the term LGBTI or LGBT in this presentation, but people have all different words for sexual orientation and gender identity around the world. So just because somebody doesn't use that same language doesn't mean they may not have a fear for this basis. And some people may explicitly not identify as gay. For example, there's the MSM, men who have sex with M movement. And so some men might identify as MSM but would deny being gay because they might associate gay with sort of what role you play rather than who you're having sex with. So those are the kinds of things that you want to familiarize yourself with when you have somebody from a particular country is, what terms are used in that country and how is sexual orientation and identity understood in that country. Okay, we can move on. So here's one persecution. Jennifer is a transgender woman from Honduras. She was at a gay club there that was raided by the police. The police arrested her and took her to the local jail where she was detained without charge for several days. While she was detained, 2 police officers and an inmate sexually abused her. So the question is, does this rise to the level of persecution? So we know she's been detained, right, and arrested. without charge. So is this legitimate prosecution? It sounds like she hasn't done anything illegal from the facts we've been given, so this probably isn't legal prosecution. So we'd want to look at what was her condition like in detention, how long was she detained. If she's been there several days, that sounds quite severe, more than say if somebody was just detained for an hour. And then we have the sexual abuse, which would, in my mind, clearly raise it to the level of persecution. And you'll notice this abuse in this hypo was both by officers and by an inmate. So we'll talk about the difference between harm by the government and harm by another private individual. And in this case, if the officers either encouraged other inmates to sexually abuse her or did nothing about it, that could also implicate the officers further in the persecution. We can go on to the next slide. So this is a different situation that might be a little tougher to decide. So Jorge is a 19-year-old gay man from El Salvador. He never came out in El Salvador because he was afraid of what would happen. But people suspected he was gay. He was constantly teased at school and called names. His teachers did nothing to stop this. Twice when he was in high school, gang members threatened that they would, quote, make him a man, but he was never physically harmed. He's been out since he entered the US 6 months ago. So here's someone who has never actually experienced a serious harm in terms of physical violence or sexual violence in his home country. And this case would probably be based more on a well-founded fear without past persecution. Though, of course, you'd want to look at how both his young age is something you would take into consideration, because persecution is actually based on the identity of the person. So the level of harm needed to constitute persecution of a child, say, or an elderly person, is not as high as of an adult. So depending on how severe the psychological harm and harassment was, the name calling was, but regardless, this would probably be a tough one to show past persecution and would be based more on well-founded fear. Though he has experienced a couple serious threats, so make him a man is probably meaning a threat of rape, and so that would be a pretty serious threat. And if these gang members have the ability to carry it out, that could amount to past persecution. In every case, I would argue past persecution. There's no reason not to make the argument as long as you can make a plausible case for it. So I certainly would still argue it here, emphasizing his young age and the seriousness of these threats. But I would know while doing that this would be very important to show well-founded fear in this case and not rely on past persecution. Okay, we can go on. Okay, so one way to show persecution, both physical and mental harm, is through professional expert evaluations. These are really extremely important to do in asylum cases. I almost always try to get at least a psychological evaluation, even if I'm not going to have the expert testify. And what that evaluation helps show is the severity of the harm that the person experienced. So for example, a diagnosis of PTSD, depression, or anxiety, all those things can help show that the harm the person experienced was severe harm and not just sort of mild psychological harm. These, I'm going to get to credibility in a bit, but these types of evaluations also help deal with credibility issues that might come up. Often when people have gone through severe trauma, particularly sexual trauma, they may be resistant to talking about it or even remembering it, and that can affect the detail of their testimony and the consistency of their testimony. So it's important to sort of deal with that on the front end by having a psychological evaluation that explains how the trauma can affect memory and testimony. And sometimes if I think there's a real serious problem with that, I'll actually have the psychological expert testify first to sort of get that out before I even call my client to testify about their experience. A medical evaluation can also be useful if there's actual physical injury or scars from the abuse. And most of the time they can't say, this was caused by a rape or a beating or whatever, but they can say that this scar is consistent with being hacked with a machete or whatever happened. So they can at least say that it's consistent with the type of injury being alleged, even if they can't verify causation. And so that's really good corroborating evidence. All right, next slide, please. So past persecution is very helpful, and I'll I'll say how basically that creates a presumption of well-founded fear. But even without that, you can still establish a well-founded fear and get asylum on that basis. So well-founded fear actually has two components, a subjective fear and an objective fear. The subjective fear is usually quite easy to establish through testimony, as long as the person is credible. Objective fear, on the other hand, requires quite a bit of documentation. So this is where it's really important to do your research and get country conditions reports about the status and treatment of LGBT individuals in the country at issue, where the expert testimony comes in, and where you want to get as much corroborating evidence as possible. So under the Real ID Act of 2005, if corroborating evidence is, quote, reasonably available, you're supposed to get it, and failure to get it can actually be a basis for denying asylum. So if there are police reports or medical records that you haven't attempted to get, that can be a basis for denying asylum. Now, if your client hasn't been able to get them, they can testify about why they couldn't, and that can help show that it was unreasonable to expect those documents. Past incidents that don't rise to the level of persecution, so sort of discrimination or harassment, can still help show a well-founded fear. And so you still want to include all of those. A 10% chance of persecution is enough to win asylum, so it's not a super high standard. And I'm going to compare that to withholding of removal later, where you need actually more likely than not standards, so greater than 50% chance. Next slide, please. So as I mentioned, past persecution establishes a rebuttable presumption, and that's why it's so helpful to have past persecution. Once you can show past persecution, the burden now shifts to the government to actually show why the person doesn't have a well-founded fear. And there's two ways the government can rebut that presumption. One is by showing a fundamental change in circumstances, such that the person no longer has a well-founded fear. And the second way is internal relocation, which means the person, it would be safe somewhere else within their country. So they can say, well, maybe you were persecuted in this rural village, right? But why can't you move to the capital city? And there are gay clubs there, that, you know, the capital is more accepting of being LGBT, those types of arguments. And so you need to show why it's actually unreasonable to be internally relocated within the country. And there's good case law on that. So, for example, there's cases that say internal relocation has to be reasonable, considering the different factors about this person. So, for example, their age, their education level, their work history. So you can't expect a child to just pick up and move to a different part of the country, or somebody with no education to go find a job in the capital where they may not be able to get any work. So those kinds of factors are relevant. Okay, so here's another hypo. So Amir is a bisexual man from Malaysia. While married to a woman, he was in a secret relationship with another man for about 10 years. No one ever found out about his same-sex relationship. Sodomy, but not homosexuality, is a crime in Malaysia, punishable by 20 years in jail and flogging. So the question here is, there's no past persecution, at least there's no past physical harm or anything that would, on its face appear to be past persecution. In terms of well-founded fear, we'd be relying heavily in this case on the country conditions, and in particular on this harsh law. So this is a case, I had a case with this issue from Malaysia, and in that case the judge, was an LA immigration court judge, ruled that sodomy but not homosexuality was a crime. Now that went against Ninth Circuit case law that actually says you can't draw that distinction in terms of the risk the person faces based on their sexual orientation. So that case was overruled on appeal, and that decision was overruled on appeal. And so in a case like this, where a country is, punishing sodomy with this very severe and disproportionate punishment of 20 years and flogging, that should amount to well-founded fear, especially if that law is enforced. And that issue of enforcement does come up quite a bit. But as long as you can show there's at least some enforcement of the law, you should be able to meet that 10% chance of future persecution threshold. Next slide, please. Thanks. So in looking at whether prosecution amounts to persecution, some of the factors to consider and that asylum officers and judges will consider are sort of the general applicability of the law, how it's enforced, how the persecutors view those who violate the law, whether the punishment is unduly harsh. I mean, recall sodomy was a crime in the US until very, very recently. So, you know, again, it depends on how harsh is the punishment for that and how much is it enforced. And how would compliance affect the person's life with respect to the protected characteristic? Does it really get to sort of the heart of what that characteristic is? Next slide. Okay, so here's another well-founded fear hypo. Anna is a lesbian from Russia. When her family found out she was gay, they forced her to see a doctor who tried to cure her of her lesbianism. She was hospitalized against her will and subjected to electroshock therapy for several weeks. Afterwards, she began using drugs and attempted suicide by overdosing. So in this case, I would say there was past persecution because of this electroshock therapy. Just because somebody's intentions are good and maybe their desire is to cure her and not actually to harm her, it doesn't matter. It doesn't undercut her asylum claim based on the harm that she suffered. So there's a similar Ninth Circuit case to this where this was the sort of conversion treatment and the court ruled that this was persecution. And so because we have past persecution here, we get that presumption of well-founded fear, and the burden would shift to the government. Now, the fact that she had the past suicide attempt and overdosing and using drugs, all of that can help show with a psychological evaluation, could help tie those incidents to the harm that was inflicted on her to help show how severe the harm was. And that would all go towards well-founded fear. Next slide, please. Thank you. So additional psychological consequences of being LGBT in certain countries where that is, where there's a lot of discrimination or persecution is people's identity development can be delayed or, just not go as normal. Internalized homophobia is very common. So this is one of the reasons why people may not even identify as gay or might not be forthcoming about being gay. Sexual functioning can be affected. So just because your client hasn't been in a same-sex relationship or isn't even sexually active, that doesn't mean they don't have a claim based on sexual orientation or gender identity. Self-esteem can be affected, and people sometimes minimize the history of violence, and that can be a coping mechanism where they don't really want to come face to face with the full harm that they've experienced. All right, next slide, please. Often we see cases where LGBT individuals were abused as children, and that type of childhood sexual abuse in particular can be so traumatic that it amplifies the trauma by subsequent events and affects memory. And there's often abuse within families by direct family members or extended family members, and as well as sort of more general the lack of support that people face, and all of that amplifies the psychological harm. So after persecution and well-founded fear, the next element in the asylum definition is nexus. And by nexus, that's sort of the connection between the harm and the reason for the harm. So those are the words on account of, and then we have the 5 grounds, so race, religion, political opinion, nationality, or membership in a particular social group. So the question is, how do we show that the harm was on account of one of those 5 grounds? Well, under the Real ID Act, again, you have to show that the protected ground was a central reason for the persecution. So not just a small part of the reason, but a central reason. And this can be difficult to establish in some cases. And you can use both direct and circumstantial evidence to establish it. And I'll give some examples of each. Next slide, please. So direct evidence can include, for example, the persecutor actually warning the applicant to stop the behavior or activity, right? So sort of a threat of, I'll harm you if you keep doing this. Actual statements made by the persecutor, often during an incident of harm. So if somebody is beating someone and actively making derogatory slurs about their sexual orientation or about their gender identity, then that in itself could be evidence of nexus. And there's also been decisions saying even sort of laws prohibiting or punishing homosexual activity can help demonstrate a nexus. Now moving on to the next slide, in terms of circumstantial evidence, you could show that the persecution has harmed others. So if other gay or transgender people have been harmed by this person. That can help show that that is a motivating factor. The proximity in time, so after somebody was seen, say, at a gay club, they're stopped on the street and beaten. That could help connect the beating to their sexual orientation. And again, country conditions reports showing more generally how people with that characteristic are viewed can also go to Nexus. Okay, so here's a hypo on Nexus. So in Mexico, Leticia lived with her female partner, Juana. They had a turbulent relationship. When Juana was angry or jealous, she often became physically and verbally abusive towards Leticia. Juana beat Leticia and called her names like stupid slut. What if Leticia tells you that Juana was also physically abusive towards her younger sister and brothers, none of whom are gay? Okay, so before we get to the what if part, initially with this hypo, we have basically a same-sex relationship with domestic violence. And the question is, do we have a nexus? Meaning, was Juana beating Leticia because of her sexual orientation? In DV cases, it can often be difficult to show nexus because judges will think, well, maybe Juana is just a violent person. And how do we know that the reason she's beating her partner has anything to do with her sexual orientation, as opposed to just being a violent person? And so that is a tough situation where you really want to put together as much evidence as you can. So here I gave one example of a name Juana called her partner, but that's not, that might have a gendered aspect to it. It doesn't necessarily have a sexual orientation aspect to it. So you'd want to sort of really flesh this out to get as much information, if Leticia was your client, as possible about other things Juana said or did. You know, is this violence related to internalized homophobia of some kind? Did she treat other people this way, or only only other women she's dated? So if you find out that Juana is also sort of abusive towards other people, and this is the kind of question a government might ask during cross-examination, you know, if she's violent towards men as well and towards straight women, it's going to be harder to show that nexus, that the abuse was on account of sexual orientation. Doesn't mean you can't show it or shouldn't try to show it, but those are the kinds of facts that make it harder and that the government will dig into. Next slide, please. Okay, so I think I mentioned this earlier with the electroshock conversion therapy hypo, is you don't need punitive or malignant intent. Female genital mutilation is another example like that. It's often done by the family. They think it's for the girl's own good or benefit. Nobody's trying to inflict harm, yet we know it's a very harmful practice. And that's not a problem in terms of establishing a nexus. Okay, so the last element are the 5 protected grounds, which are race, nationality, religion, political opinion, and membership in a particular social group. So the first 4 tend to be pretty clear, and social group 1 tends to be quite confusing. And it's gotten more confusing in recent years as the definition of a social group has become more complicated. So I'm going to talk about social group and a little bit about political opinion, because those are the 2 that come up the most in LGBT cases, but you always want to check for all 5 grounds. Just because you know you have a sexual orientation claim doesn't mean you ignore possible religion or race-related claims as well. So be sure you don't sort of focus in on sexual orientation to the exclusion of these other grounds. Next slide, please. Okay, so a social group now has 3 requirements. Immutable characteristic, which is a long-standing requirement from 1985, and an immutable characteristic is something that you can't change or should not have to change because it's fundamental to our identity. So whether or not you think sexual orientation is fluid or static or you're born with it or not, it actually doesn't really matter because you shouldn't have to change it, is the theory, if it's fundamental to your identity. So it's definitely an immutable characteristic that's well established in the case law. In recent years, the Board of Immigration Appeals has added 2 other requirements that have been challenged. And there's a little bit of a circuit split on this. The 7th Circuit, for example, has rejected these 2, but most of the circuits now have accepted them. But this is another place where you really want to look at the case law in the circuit. So the 2 other criteria are particularity and social distinction. And advocates often find these hard to tell apart for good reason. So particularity means that the boundaries of the group are clearly defined, so you can identify who's in the group and out of the group. So the types of words that have been rejected is say something like intellectuals or youth. Those types of words are too vague. We don't know who qualifies as an intellectual and who doesn't, or we don't know what the cutoff age is for youth. So you don't know who's in the group or out of the group. And so that can be challenged, or a judge might find that that group lacks particularity. The third requirement is the social distinction requirement, which used to be called social visibility, but the BI has clarified that it's social distinction. And what that means is in the country, in the society where this person lived, right, did society view their group as distinct from the rest of society? So were LGBT people viewed sort of as a group, or some subset, say gay men viewed as a group? It doesn't require literal visibility. Now, as a practical matter, sexual orientation has been so well established as a social group that you don't tend to have a lot of problems meeting these three requirements, mostly because courts aren't drilling down into them now because it's been established for so long. But social distinction may or may not be there for LGBT issues depending on the country at stake. For example, if you take Iran, where you had the former president Ahmadinejad deny that there were any homosexuals in Iran, I mean, that raises a question of, are they socially visible as a group if people are denying that they exist? But as I've said, for the most part, if those are your grounds, if that is your group, it's not going to be a problem. Next slide, please. So sexual orientation and gender identity have both been established. Gender is still an area where there's case law now a little bit. For example, married women who are unable to leave the relationship has been accepted in a precedent decision involving a woman who was subjected to DV in Guatemala by her husband. But gender alone is still difficult to establish as a social group in the US in most courts. Other social groups that might be relevant are family membership or former occupation, status, or experience. And political opinion can include things like opinions about gender roles or feminism and opinions about LGBT rights. So that might be an additional claim you make if the person says, I'm out, I'm an advocate for LGBT rights in my country, and because of my opinion, I might be targeted or I will be targeted. In that case, you would want to include political opinion as well. So all of the grounds, all of the protected characteristics and all of the 5 grounds can be actual or imputed. So actual means you actually belong to the group, and imputed means people think you belong to the group, whether or not you really do. So for example, homosexuality is often imputed whether or not it's there. So somebody who is, say, effeminate and is perceived as being gay can still get asylum based on imputed homosexuality, even though they're not really gay. Or in transgender cases, we often argue imputed homosexuality as a second reason in addition to gender identity, because people there might not be actually persecuting them as a transgender person, but persecuting them because they think they're gay. So it's usually good to make both arguments in a brief. Credibility is one of the trickiest parts of asylum, and this in LGBT cases can take on sort of unique problems. But the types of things that judges are allowed to look at in deciding credibility are obviously inconsistencies in their testimony or between their written documents and their testimony, the plausibility of the story, the level of detail in the story, how responsive the person was to questions. So if the judge felt like they weren't directly answering a question or sort of circuitously answering, that can be a basis for finding the person not credible. And then finally, demeanor, even just how the person acts, their facial expressions, their hand gestures, their eye contact, all of that thing can factor into credibility. And judges have really enormous discretion to make adverse credibility findings, and those are very hard to get reversed on appeal. So in LGBT cases, some judges have really questioned whether the person is actually gay or transgender. And unfortunately, due to, again, who our judges are, how well-versed they may be in this area, they might have very stereotypical views about what LGBT individuals should look like or how they should present and act and talk and dress and all of that. So if the person doesn't conform to that stereotype, they might really question whether the person is really gay. Especially because sexual orientation is a well-established ground for asylum. They're suspicious that people will say they're gay just to get asylum. Sometimes, you know, these stories are very, very, oh, sorry, can we go back to the prior slide? Sometimes the stories do involve severe harm, and judges tend to be suspicious of that. For example, torture or repeated rape. Sometimes judges will think somebody's exaggerating, but, you know, that may actually be, often is what happened. Okay, next slide, please. So here's a credibility issue. So Aziz is a 25-year-old man from Egypt who says he was entrapped by an undercover police officer on a gay dating website. He was arrested and brutally tortured at the police station. So some of the inconsistencies that come up, say when you're interviewing him or in his testimony in court, are how many officers tortured him, whether there were 3 or 4 officers. He's given different names for the dating website where he met with this undercover, where he met the undercover officer. He doesn't make eye contact or looks nervous when he's talking. He doesn't remember certain details like what the officer was wearing when they met or when they met, but he does remember where they met. So those types of things can all be relevant. Now, this is not a case where just because of these things I would start doubting my client's credibility. These are very common types of inconsistencies or you know, issues with memory. But there are things to be very aware of and to prepare your client for before you go to court, because things like how many officers tortured the person or what they were wearing are the types of questions that are routinely asked. And so if your client gives discrepant answers about that in court, that could be a basis for denying. So when you're practicing with your client, you want to make sure you get the story straight. Demeanor, unfortunately, you know, can be very different depending on people's experiences and cultures. So I often just have a very frank conversation with clients about demeanor. What judges here tend to interpret as being, you know, that not making eye contact is a sign of sort of lying in the US, or not showing emotion might make them doubt that this really happened. And this is just to let clients know. And if your client really has a very different demeanor of some kind, then it's sometimes even helpful to build the record with evidence of that, or to incorporate some of that into the psychological evaluation to show that it is related to the trauma or to the particular culture where the person is from. Next slide, please. So here's another credibility hypo. Dembe is a woman from Uganda. She is married to a man but says she is bisexual. She had one romantic relationship with a woman many years ago, but has never had sex with a woman. She has never gone to any gay bars or clubs and does not participate in any LGBT organizations or events. She has a very feminine appearance, has been married for 10 years, so this is to her husband, and has 2 children, her husband. So this is a case where, you know, you may have no suspicions about your client. You may think, well, fine, she's bisexual, she just hasn't acted on that much. But this is a case where a judge might really question whether she's in fact bisexual or just using that as a way to get asylum. And so one question sometimes clients have is, okay, I wasn't out at all in my home country. Is it important for me to be out here in the US or to do things in the US to show that I'm LGBT? And, you know, I usually tell clients that, yes, it is helpful. So you obviously don't want a client to do something that, you know, just for the sake of their asylum case, or that would be a lie. But, you know, just because somebody didn't do it in their own country doesn't mean they're unwilling to do it here. And so letting them know that, you know, joining LGBT organizations in the US or coming out here can really help show that they are the identity that they say they are, especially in this type of situation where there's really not a lot of past evidence of that identity that you could produce. The persecutors of LGBT individuals tend to be both private and public, so government, family members, community, people at school or in the workplace. Those would be the private actors, and sort of police or soldiers, judiciary, those would be the public actors. And when you're dealing with private actors, there's additional things you need to prove up in an asylum case. Next slide, please. So when you have harm by private actors, you have to show that the government was either unable or unwilling to provide protection. And those are 2 different things. So unable means maybe they want to. It's not that the government isn't trying to help, but they just don't have the capability. So for example, gang violence, even if you can show the government wants to stop it, the level of it kind of indicates that the government is unable to stop it. And in other cases, the government may just be unwilling to help LGBT individuals, for example. Next slide. So when courts consider whether whether the government was unable or unwilling to protect someone, one of the first things they look at is, did the person try to get the government's help? Which means, did they try to report to the police? And if they didn't, why didn't they? So the lack of reporting is an issue that needs to be directly addressed by the advocate. And this is, again, an area that's fleshed out by case law, but there's at least two sort of established excuses for not reporting in the case law. And one is if it would be futile, meaning the police wouldn't do anything. And you can show with the country conditions reports that police don't ever take action when these types of reports are made. And the second would be if you can show that reporting would actually put the individual at risk of greater harm. And that could be either because the police themselves would harm the person if they came to report, say, an incident of abuse as based on their sexual orientation or gender identity, or if the original persecutor but that they're reporting would retaliate against them for reporting, and so basically they would be subjected to even greater harm in the future. So here's a hypo. Veronica is a transgender woman from Mexico. As a teenager, she was raped by an uncle and two cousins. As an adult, she was raped by a man she met at a bar. She never reported any of these rapes to the police. She says that she felt too ashamed to report them and also did not think the police would do anything to help her. So this is a case of, we have to explain, she has these 3 rapes, right? But they were all by private actors. And so if she can't show that the police were unable or unwilling to protect her, she's not going to win asylum despite the past persecution that she clearly experienced. So in this case, it's going to be really important to show why she didn't report and to provide country conditions or expert testimony that the police in that country wouldn't investigate these rapes if she had reported because she's transgender, and that the police may have even abused her themselves and raped her further. Next slide, thanks. Okay, so the 1-year deadline is a unique part of U.S. asylum law in the sense that there's no real basis for it in the international convention. So normally you have to apply for asylum within 1 year of entering the U.S., and there are exceptions from that. And often our LGBT clients have gone beyond the 1-year deadline, in part because they may not have known about asylum when they came here, or they were scared in their own country of mentioning their sexual orientation. So sort of going to a lawyer and disclosing their sexual orientation and asking for help applying for asylum usually isn't on the front of their minds, especially if they're just sort of dealing with a past trauma, starting a transition. These are all things that delay people from applying for asylum within 1 year. So the types of changed circumstances that can get you around that are on the next slide. So if somebody just came out, that's an excellent changed circumstance. So you have to show that this change affects your eligibility for asylum. So that before somebody came out, they were at less risk, but now that they're out, they would be at much higher risk of persecution in their home country. Steps taken to transition to a new gender, that can also be one of those major changes that can create an exception. A recent diagnosis of, say, HIV. PTSD is used in most of these cases, is tried, but is often unsuccessful. I think you would have to show that it was really severe. But if you've had somebody who's been here for years and the explanation is PTSD, it's probably not going to work, at least in my experience. And then, of course, changes not just in the person, but in the country can also be a basis for getting around the 1-year law. So if there's changes there in the government or in the legal system there that would put the client at greater risk, that can also be used. And then ineffective assistance of counsel is not listed here, but that's another exceptional reason, basically, where if somebody was told, like, you don't qualify for asylum because you're gay, you could probably get around the 1-year bar based on that type of ineffective assistance. Okay, there's also several bars to asylum, and it's important to know these so that you can advise your client about other options if asylum isn't a possibility. So those of you who know immigration law know that an aggravated felony is a term of art in immigration law, and it has a very expansive definition. It doesn't have to be aggravated, and it doesn't have to be a felony. So it is a bar to asylum, and in order to decide if your client has been convicted of a, quote, aggravated felony, you need to look at INA 101A42, which has a definition of that. And if you're not an immigration lawyer and you're sort of doing an asylum case, it might be helpful to speak to an immigration lawyer about the client's criminal history to help determine if it is an aggravated felony, because it's very counterintuitive. Another term of art, and this actually comes from the Refugee Convention, is a particularly serious crime. This also is not defined by statute, except that the statute says any aggravated felony is automatically a particularly serious crime that bars asylum. But it's not the only thing. So there could be lots of other crimes that aren't aggravated felonies, but that can be deemed particularly serious. And the Board of Immigration Appeals has a test for sort of a multi-factor test to decide if a crime is particularly serious. But the way that case law has evolved is that there is very subjective decisions made. It has included violent and non-violent crimes, crimes against people, and crimes against property, even financial crimes. So you really, again, need to look at the case law there. It's quite subjective. Firm resettlement in a third country. So the INA requires an offer of permanent, basically, residence or the equivalent in a third country. So just because somebody has been somewhere for a long time doesn't mean they're firmly resettled. But if, say, they were offered asylum in another country and now they're seeking asylum in the US, that would be a bar. And finally, persecuting somebody else based on race, religion, nationality, political opinion, or membership in a social group is also a bar for asylum. So you can't be a persecutor of others and get asylum. Next slide, please. Okay, so here's a couple hypos. So Zaid is a gay man from Iraq. He was convicted of misdemeanor theft and received a suspended sentence of 1 year. Is he eligible for asylum? So you might think, oh, it's a misdemeanor. Doesn't sound that bad. Maybe it's a shoplifting, right? And he didn't even do any time. It was a suspended sentence. Well, this is an aggravated felony under immigration law because it's a theft offense with a sentence of 1 year, which is an aggravated felony. And immigration law doesn't care if it's suspended or not suspended. It's what the sentence was, even if you serve no time. So Zaid is actually barred from asylum under our laws. So you want to be aware of that right away, okay? Amina is a lesbian from Afghanistan. Before arriving in the US, she spent 3 years at a refugee camp in the Netherlands. Is she eligible for asylum? So you might think, oh, she was at a refugee camp for several years. Looks like she was firmly resettled. But that is not the right analysis. So you need to see, did she ever actually get an offer of permanent residency from the Netherlands? Was she actually granted asylum by the Netherlands, right? Or was she just in a camp waiting for an adjudication? I mean, I've had clients who've been in another country for 6, 7 years at a refugee camp, but never had a grant on an application and then came to the US. They are still eligible for asylum in the US because they were never given an offer from another country to stay there. They were just happened to be there. But the longer the person spends in another country, the harder it's going to be to show that they were not firmly resettled. And so you want to push back with all the evidence you can to show that actually they were not firmly resettled. And this is a burden shifting test again. So the government needs to offer some type of evidence that the person lived abroad for a long time, and then the burden shifts to your client or to you to show that they didn't have an offer. So it's kind of and different circuits might do this differently, but this is the general way it works. Next slide, please. Okay, so if somebody is barred from asylum, there's still other possibilities. Withholding of removal is actually how the U.S. Has coded the non-refoulement obligation under the Refugee Convention. So there's no 1 year bar for withholding of removal. And then finally, there's something called deferral of removal under the Convention Against Torture. For both of these, there's no path to permanent residence or anything, but the person is basically allowed to live in the U.S. and to get a work permit. So they're not going to be deported and they're able to work legally, but they're not going to get refugee status. And refugee status, so for example, if somebody is granted asylum, after 1 year as an asylee, they can apply to become a permanent resident. So they're on a path to citizenship. Individuals granted withholding or deferral under CAT don't get on a path to anything. And if they leave the country, they're not going to have a way to come back in. So for withholding of removal, there is a higher standard. You have to show a greater than 50% chance of future persecution. And it's the same definition of a refugee as for asylum. There's also a particularly serious crime bar, but it's more severe than the one for asylum. So it's an aggravated felony plus a sentence of at least 5 years for that offense. So for CAT, you have to show a greater than 50% chance of torture, which is a higher standard than persecution. And torture has to be by or with the acquiescence of the government. So when you have a private actor, it becomes much harder to show CAT. You would have to show that the government knew about it and sort of willfully blind to it happening. The good thing about CAT is that there's absolutely no criminal bar. So even somebody with 10 aggravated felonies could still be eligible for protection under the Convention Against Torture. And there's no nexus to a protected ground. So in LGBT cases, you usually have your protected ground and your nexus. But in other types of cases, sometimes those are the harder parts, and then you can argue CAT more forcefully. Next slide. It's important to always argue withholding and CAT, even if your client is eligible for asylum, because asylum is ultimately discretionary. So just because your client meets the definition and doesn't have any of the bars doesn't mean they'll be automatically granted asylum. They might have other incidents in their lives or criminal history that isn't an aggravated felony or a particularly serious crime, but the judge can still decide in their discretion that they're going to deny asylum. Whereas withholding and CAT are not discretionary. So I always include those in every application. So here's a hypo. Salome is a transgender woman from Mexico. She entered the US 3 years ago and now wants to apply for asylum. She has been arrested 5 times for prostitution and convicted twice. She also has a DUI conviction. Okay, so looking at these facts, none of these incidents that she has are actually going to amount to an aggravated felony. So she's not barred from asylum, right? But the judge might look at it and say, all of these prostitution offenses and a DUI, I don't want to grant her asylum in my discretion. So you need to be prepared to sort of deal with that on the front end and really try to link these offenses to the suffering she experienced on account of her gender identity. So often for transgender individuals, there's so many lines of work cut off from them that sex work is one of the few lines of work they can do, especially in other countries. So if you can show that sort of prostitution was the only option for her, or one of the only options for her, or that she's, targeted for prostitution even when she's not engaged in prostitution. So police just automatically arrest her for prostitution just for being a transgender woman walking down the street. And so that's another way to show that just because she has all these arrests doesn't mean she's actually been engaging in prostitution that much. And the DUI, again, you want to ask, is there a way that substance abuse is related to the psychological harm she's suffering? Can I paint these facts in a more sympathetic way so that the judge isn't going to just think of her as a substance abuser or as a prostitute and want to deny her asylum on that basis? Now, if she's been convicted of something more serious like sale of meth and sentenced to 6 years, she's going to be ineligible for asylum and ineligible for withholding because that conviction is going to be an aggravated felony with a sentence of more than 5 years. So the only thing she's going to be eligible for there would be CAT. And so that's when CAT really comes in handy, is when somebody has a crime that's going to bar both asylum and withholding. All right, the last point I wanted to touch on was detention. So a lot of LGBT people are in detention in the US, and that complicates representing them in many ways. So both they might be far away from you, hard to access, right? Which means if you're talking mostly by phone to them, they may not be as willing to disclose all of the incidents to you. It's really important to have contact visits if you can, so you can have private conversations. But the actual conditions of detention themselves also can be very harmful. So as Alice mentioned earlier, UNHCR has
written excellent reports on this, but sort of the sexual and physical abuse that LGBT individuals suffer, the lack of proper medical and mental health care, and even the use of sort of solitary confinement or isolation. Sometimes detention centers will say it's administrative isolation for the person's own good. It's not meant to be punitive, but it still has the same psychological harm as any other type of solitary confinement. So that can all affect the person's ability to cooperate with you and testify and want to even pursue their asylum case. So in terms of appearing in court, when somebody is detained, not only is it harder for you to communicate with them, but it's harder for them to communicate with the judge. And that's because they're now very limited in how they can present themselves and dress and talk and behave. And people often will change their behavior in detention to protect themselves. So somebody who's transgender may not even appear transgender in detention because they don't want to be assaulted by other inmates or by guards. So they're presenting themselves in a very different way. And that can affect how the judge sees them and their credibility, what the judge perceives as whether they're credible. Also, in the US now, most detained cases are done by video. So in these video hearings, there might be other inmates, sort of detainees mulling around in the background. There's less privacy. It's harder for the IJ to actually see the client or view them as a person. And all those things make it harder for them to win their cases. So we'll do one last case example, I think, to try to pull these topics together, and then we'll go to questions.
Yeah, that sounds good. We got some good questions already, so maybe if we can go through this one just a little more quickly, and I can talk about some international guidance that might be helpful as well.
Sure. Okay, so I'll just read it. Sarah, a 24-year-old transgender woman, was born and raised in a rural town in Oaxaca, Mexico. She was born biologically male, but began using the name Sarah when she was 14 because she always felt she was more female than male. Because of her gender identity, Sarah suffered years of relentless abuse from family members that included harassment, sexual assault, and rape. Throughout her childhood, Sarah was repeatedly harassed by classmates for her effeminate appearance and behavior. At 16, she moved out of her family's home because her father beat her and would not allow her to dress as a woman. Despite moving out of her family's home, Sarah continued to suffer from abuse. She began working at a bar and was raped by one of her customers. Following the attack, Sarah fled to the US in search of protection. Despite Sarah's constant abuse, she never reported these incidents to the police. Sarah has stated she was afraid to report to the police after hearing stories of police mistreatment of transgender women. So just thinking through the elements of asylum, right, we want to say, well, first, did she experience past persecution? So here she has years of abuse, right, including sexual assault and rape. That's very severe. And so as long as we can show that that was on account of her her gender identity in this case, then we shouldn't have a problem establishing past persecution. And that would trigger the presumption of well-founded fear, right? But all of her harassment here and her assaults here were by private individuals, because it says from family members, classmates, right? So that means we have to show the government was unable or unwilling to protect her. And that's where her failure to report is going to come up, right? So why didn't she go to the police with any of these incidents? And we'll want to know, in Mexico, how are the police responding to reports of violence by transgender women? And she can show that they wouldn't take it seriously or that they would harm her when she reported. That would excuse her failure to report. Doesn't sound like she has a criminal history. We'd want to know when she entered the US, right, to see if she's got a one-year issue. But other than that, I would say that she's in a really good place to apply for asylum. I'll let Alistair and Colleen chip in additional analysis.
Yeah, I would just mention that some of the guidance that we already talked about would also be relevant to incorporating in this claim. The Women on the Run report could be used to kind of show evidence of surrounding circumstances that this woman does have a credible fear because of what else is happening in the country and the heightened risk of transgender persons. Also, the sexual orientation guidelines could be used as part of the well-founded fear analysis, or the guidelines also talk about particular social group and how that could be formulated and it could help this case. One thing I didn't talk about but could be relevant here, since some of the harms occurred when she was a child, between the ages of 14 and 16, from the facts that we have here. UNHCR also has guidelines on child asylum claims, and those talk about how harms should be viewed from a child-sensitive perspective when the applicant did experience harms when they were under the age of 18. So all of that guidance could be used to support this claim. And I would also just flag that on our website, we did prepare a sort of guidance note for going through the different stages of the refugee definition and then comparing it to U.S. law and cases that have been successful in these areas. And so that's something that's on our website that I can also send out after the presentation. So with that, we can take more questions. I have some in the queue already, but feel free to type your questions in. The first question we have is how do you address the use of pronouns, and how do you correct the IJ's use of incorrect pronouns?
That's a great question. So, I mean, you address it. I actually usually will, well, first of all, in the declarations and everything I submit, I will make it clear what pronoun the person uses. And then often the IJs will just start out using the pronoun of however they're charged. So it'll often be their biological sex and not their gender identity. And I would just correct the IJ at the first hearing and say, you know, my client prefers to be called whatever name they use and whatever pronoun they use. And I would just continue to use that in my direct exam or whenever I speak to my client. Now, often the government will not use it and the judge may not use it, and I try to correct the judge, but you know, I would just get ready to expect that to happen, and I would prepare my client to also be ready for that.
Okay, great. That's very helpful. Another question from the latter half of the presentation is when we talked about particular social group, we also mentioned family membership as a potential social group. So a question about providing a successful hypo of how this might come up. I'm sure Palma has some concrete examples, but I would also point UNHCR has a gang guidance note that talks about family membership as a PSG and how it might arise in those cases. For instance, if a family member has reported a crime to the police, you know, their children or their relatives might also be targeted because of their relation to that family member that reported the crime. But Bob, I don't know if you have any more specific examples in regards to LGBT cases.
So, I mean, you might have a client who's not LGBT, but who has a family member who is. And if your client is facing a risk of harm because of having this LGBT family member, that would be, you know, a way to use family as a social group. In LGBT cases, because you have often the person's actual sexual orientation or gender identity as a group, you probably won't need to use family for that person. But you know, sometimes it can be an additional ground. Also, you should be aware that there's a circuit split on family now, where some circuits say the family member that you're defining the group based on also needs to be protected on account of also needs to have been targeted for one of the grounds. And other circuits say they don't. So let me give you an example. So let's say somebody's at risk because of the relationship to their father, and their father is being targeted for his political opinion, right? Then the family member who's defining the group, which is the father, is also being targeted on a protected ground. And that would be a clear case of family membership as a social group. But let's say the father is being targeted for some completely different reason. That's none of the 5 convention grounds. Then there's a circuit split where not all circuits will recognize that, because the father wouldn't be eligible for asylum, but the family member would. So just to keep an eye on that as an evolving area of case law.
Okay, great. Thanks for that. And another question relating to the elements of an asylum claim, this time in regards to the persecution element. You talked about how age might be a factor in establishing persecution. and the question is, could you expand on this, particularly for young adults, so individuals between the ages of 19 to 25? I'm going to hand it over to Fama, but before I do, I just want to mention that UNHCR does have guidance on child asylum claims. It relates mostly to children under the age of 18, so might not be relevant for your particular question, but it does talk about certain forms of persecution that are specific to child claims, as well as how the persecution element should be examined from a child's perspective.
So because the U.S. immigration law defines a child as under 21, I will go up to 21 in arguing that somebody is a child. I think once you're dealing with somebody who's like 24 or 23, it's going to be harder to show that the level of harm should be calibrated. But you can also look at other factors like that person's education level, you know, their IQ. There's lots of other factors that could still possibly lower the threshold of harm, whether they have any physical or mental illness. So somebody who's very frail or ill will have a lower level of harm needed to establish persecution. So you want to look at the full picture.
Okay, great. So we're getting a few more questions about for transgender cases. The first is thoughts about transgender clients who want to change their name, any concerns about doing this in the U.S., and thoughts about timing. And then another one that's related, so I'm just going to put them together, is have you been able to get the immigration court or USCIS to change the name of a transgender person to the name he or she prefers to go by? And if so, how did you do that?
So I haven't tried to change it in immigration court. I'll try to have the court use their preferred name, but I haven't tried to sort of get them to issue the notices to a new name. And that's not to say it can't be done. I've just never tried to do it in that context. Usually afterwards, I'll do a separate process to try to get their name changed. I'm just thinking this through now, but I guess if they're able to get their names changed legally at the same time that they're in proceedings, there's no reason, I guess, not to ask the immigration court to change their name, but I think it would have to be a legal change for them to actually do it.
All right, so we have a few more minutes. I'm just going to put out a few more questions. So another sort of procedural one is, have you ever faced admissibility issues when you're introducing a medical or psychological report without calling the expert first?
I haven't actually. Of course, in immigration court, you know, everything goes to weight. There's not really any rules of evidence. So a judge could give a report less weight because you didn't call the expert. But I think I just haven't personally had that problem with expert declarations. You know, I guess if there's some dispute about the person's expertise, then that's more likely to be an issue. I usually try to have, like, a country conditions expert I'll almost always make available, you know, try to have available. Medical and psychological experts, I think they tend to be more deferential based on credentials. So they don't dispute as much the person's expertise or the content of the report.
All right, and I think one last question we can finish with is actually two questions, and I'll combine them into one, and it's sort of a more policy-related issue that relates to the last topic of detention. The question asks about evidence of that the new executive order has increased the use of detention for LGBTI asylum seekers, and do you or do we, UNHCR, have any information about plans to expand detention of LGBTI asylum seekers? So on UNHCR's end, I don't know if Alice is on the line still, but she handles a lot of detention issues.
Yeah, I'm still on the line. Yep.
All right, I don't know if you want to take that one, and then we can get input from Fatma as well.
So to address what UNHCR is doing on detention specifically.
Detention specifically, yeah, and if there's anything specific to the executive order, if you can explain why we might not want to comment on that.
Sure. So UNHCR has been we have a set of guidelines called the detention guidelines, which clarify UNHCR's position on detention. And our position is essentially that an asylum seeker should only be detained in very limited circumstances, and the vulnerable groups shouldn't be detained at all. For a number of years, UNHCR has been running something called the Beyond Detention Strategy, which is trying to work with particular countries to move practices beyond detention, and also to have much clearer ideas in the meantime, while those countries are still using some form of detention, to move much clearly towards some idea of what the standards are on conditions of confinement, particularly relevant to LGBTI, but also standards on bail or forms of release from detention. And I know that particularly when you're working with individual cases, you may end up working on trying to get your client out of detention. And that's the sort of thing that the UNHCR guidelines might be helpful in supporting. Colleen, I can't see the question written, so I'm not sure I'm being fully responsive to it.
No, I think that, yeah, I think you've answered the question. I don't know if Fatma,
Okay.
if you have anything to add.
Yeah, I mean, I can't speak sort of statistically to whether detention practices have changed. I can say anecdotally that at least here in Texas, I'm definitely seeing them detain people, for example, undergraduate students with no criminal history, people with medical histories, with serious medical issues with no criminal history, who I think previously would have been released upon request by an attorney, and now they're sort of being kept, even though they don't really pose any sort of threat. So I think there is sort of more of a push to fill beds, and that immigration officers are just feeling more empowered, I would say is what I'm sensing.
Okay, great. Well, I think that concludes the presentation. I just want to thank both of our speakers, Fatma and Alice, for participating and providing us with such helpful information. We're really grateful that you could both be a part of it. And lastly, just want to comment that we are interested in collecting a list of individuals who might be interested in taking LGBTI pro bono asylum cases. So if this is something that interests you, please feel free to send us an email. I'll be sending out the presentation as well, either this evening or tomorrow morning. But yeah, thank you all
Great.
for participating.
Thanks, Colleen.
Thank you.
Thank you. Bye.
Thanks very much. Bye.